John didn't mention I was dean of this school for 2 years, the 2 worst years of my life. Every law professor in the room can relate to that. So the general topic today is how the Constitution keeps up with the times. And what I'm going to do is talk about the Fourth Amendment and the case of United States versus Jones and how it does or does not keep up with the times. I'm going to give you a brief history of the Fourth Amendment and then talk about the Jones case. The text of the Fourth Amendment says that it protects the people, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fourth Amendment also says that the police can get a search warrant if they think they have probable cause to believe crime has been committed, and they do that by going to a judge and filling out an affidavit that says why they think a crime is committed, and then the judge will authorize the search. And the general rule under the Fourth Amendment is that police are supposed to get a search warrant. And if they don't get a search warrant and they conduct a search, then the search is unreasonable. So there's this relationship between the reasonableness clause of the Fourth Amendment and the warrant clause of the Fourth Amendment. There are a bunch of exceptions to the warrant requirement, and when I taught criminal procedure, it took 6 weeks to go through them, so I won't go through them today. But the issue I want to focus on today is what constitutes a search and seizure, and explain how that has evolved over time. The early cases, and by early I mean the 1930s, 40s, and 50s, the early cases said that it was only a search if the police physically penetrated the premises. In other words, there had to be some kind of trespass. And there were some examples of that. One example was there was a case where the police used what was called a spike mic, which they put a spike into the wall so they could hear the conversation in the next room. And the court said, yep, that's a search because that's a trespass. But the police got clever and they said, well, instead of using a spike mic, they went outside and they attached a device to the telephone wires that were outside the house, and they picked up the conversation there. And the court said, well, that's not a trespass, so that's not a search. And then they had another case where the police used something called a detectaphone. I don't think they make these anymore, by the way. Whatever a detectaphone is, you hold it against the wall, and it'll pick up the conversation in the next room. And the court said, no, no trespass, therefore, that's not a search. So in 1967, the court decided a case called Katz versus the United States. Katz was a bookie, and Katz made his bets by using a public telephone booth, and the police were onto Katz, so they attached a microphone to the exterior of the telephone booth in order to pick up his calls. And so the case got to the United States Supreme Court, and the issue was whether or not that was a search. And under the prior cases, of course, it was not a trespass because they hadn't gone into the phone booth, therefore it was not a search. Well, the Supreme Court said that the Fourth Amendment protects people, not places. And it protects people when they have what's called a reasonable expectation of privacy. And the court said Katz had a reasonable expectation in the phone booth that his telephone conversation was not going to be transmitted to the government or to the entire world. And so it was a search, which means not that the police can't get Katz's, tap his phone, but they need to get a warrant before they can do so. And after Katz, courts in the trenches, like our court, applied the reasonable expectation of privacy test. And we had a whole bunch of cases where we applied that test, including some cases involving beepers. In one case, the police put a beeper inside a drum of, it was actually chloroform, that was used in the manufacture of chemicals. And they followed the beeper as it was in the car around here and there, and they trailed the defendants, and eventually the beeper got to the house and they found out where they were making the drugs. And the rule that emerged, or seemed to emerge from that case, was that as long as the beeper was tracking public movements, that's no problem, because the police could be observing these folks. But once the beeper got into the house, that's a problem, because the house, you know, is your castle. And it's your castle even to the extent that the beeper can't transmit information coming out of your house where you have a reasonable expectation of privacy. And in another case where the police used a heat sensor, they put it across the street from a house and they were trying to figure out how much heat was being generated from the house because they were think they were growing marijuana in there, and they picked up the heat sensor from across the street, no physical penetration, and it's a house constitutionally protected area, and the court said that that was a search. So along comes Jones. And Jones interests me for a couple of reasons. One reason is that my older son was living in D.C. at the time, and he sat on the jury that convicted Mr. Jones. So after the trial, I spent a long time sitting down with him talking about the inside story of Antoine Jones and his cocaine conspirator friends and what it was like sitting on the jury and how in the world it ever turned out that this case was tried twice. First time, they had a hung jury. The jury couldn't convict in spite of the evidence. So anyway, Jones was a big drug dealer in D.C., and he had a nightclub, and they put a camera outside his nightclub so they could pick up the people who were coming in and out of his nightclub. They put a wiretap on his cell phone of all his buddies, which, you know, sounds kind of easy, but if you're a big drug dealer, you don't just have one cell phone. You have 3 cell phones, and then you change them every day. So it was a challenge for the government to wiretap the cell phone, but they did. But that wasn't enough, so they put a GPS tracking device on the undercarriage of Jones's Jeep. And they tracked him for 28 days. And the GPS data that they had led him mostly around Maryland and D.C., and it led the police to what was called a stash house, where the police eventually recovered $850,000 in cash and 97 kilos of cocaine. So the issue before the Supreme Court was whether or not this constitutes a search, putting this GPS device on the undercarriage of the Jeep. And Scalia's opinion for the court recites the history of the Fourth Amendment, and in fact he goes back to a 1765 English case where it said that if you walk on somebody else's land, even if you don't damage the land, that that's a trespass. And he said that this reasonable expectation of privacy test from Katz that you all thought was the only test for the Fourth Amendment is not. That the cases involving trespass still survive, and that Katz is one way of looking at it, but another way of looking at it is whether or not there was a trespass. And he said that putting the GPS device on the undercarriage of the Jeep was a physical intrusion on a constitutionally protected area, because a car is, you know, an effect, and therefore it violates the Fourth Amendment to put it on there without a warrant. There's a footnote. The police actually did have a warrant, but the warrant had expired after 10 days, so when they put it on, they really didn't have a warrant. In a separate opinion, Justice Alito, Scalia's usual best buddy on the United States Supreme Court, said that the court's opinion strains the language of the Fourth Amendment and is, quote, highly artificial. He said that Katz actually did away with all those trespass cases, and that we don't look to 18th century property law in order to decide Fourth Amendment cases. And he points out that under Scalia's opinion, that if the police put a GPS device under a car and tracked it for 2 days, that that would violate the Fourth Amendment. But if the police use unmarked cars and surveillance from a helicopter for 28 days, that that would not violate the Fourth Amendment. And so he says there's a problem in the application of the test. But he also says, and this is what makes the case very interesting, he also says that in this case, putting a GPS device on a car and tracking it for 28 days was unreasonable. And therefore, it violates the Fourth Amendment and violates a reasonable expectation of privacy. And he says that this case is not like a terrorist case where they need to track someone for a long period of time. It's a serious crime. This is, you know, he didn't say it this way, but this is just drugs, and that the government can't be using this kind of intrusive device to track people for long periods of time. So the bottom line is that all 9 judges found that the police conduct here violated the Fourth Amendment, and that not having a valid warrant to install the device violated the Fourth Amendment. And at least in my view, it leaves the question open as to what kind of guidance it supplies for the rest of us. You know, when I was on the court, at least, what kind of police activity is going to violate the Fourth Amendment. And Justice Sotomayor, in a concurring opinion, realized that this is a problem, and she raised the issue of smartphones, right? Your smartphone has a GPS device. Now, I didn't know that because I didn't even know how to work this thing, but they're installed at the factory. And so there's no trespass involved in it. And so the next issue, as she pointed out, and Justice Scalia actually alluded to it in his opinion a little bit, is what about the use of tracking devices with smartphones so that they can do exactly what they did in Jones without putting a device on the undercarriage of the vehicle. Since Jones, there's been at least one federal court of appeals, the Sixth Circuit, that said there's no reasonable expectation of privacy in the data that's given off by your phone. Therefore, they didn't need a warrant to put the to track the person. And the New York Times wrote an editorial saying that this is even more invasive than putting a device under the car, because you track a person with a cell phone. It's not only where they're driving to, but it's where they are in the house, where they're going to the doctor, whether they're going here, whether they're going there, that it can be a good deal more invasive. And they urged the Supreme Court to take the case and to reverse the Sixth Circuit. So, as I said at the outset, this is an area where the court is really struggling to keep up with the technology. And the technology is obviously way, way ahead of the court, and the court has got to figure out a way to deal with it in the short term. My personal view is that 40, 50 years ago, when the court decided Katz and a bunch of other cases, Congress responded by passing a comprehensive wiretap statute that all the states have to follow and the federal government follows, and it has all kinds of procedures and limitations that have been subject to litigation so that you know how long you can wiretap and what phones you can wiretap and how long you have to keep the information and that kind of stuff. This is maybe a more difficult area. I don't know, because I don't know the technology that well, but it may be that this is an area where some kind of legislative response is required, because it is a highly technical area. One of the issues is what level of cooperation can you expect from the providers? I mean, they're not all that happy about having to do all these searches for the FBI. They have other things to do, like make money, and so legislation may be one answer to this. In any event, it's an interesting line of cases because it really shows how the Constitution has evolved over a fairly long period of time in an effort to keep up with technology. Thank you.